Hi everyone, I hope everybody is okay. And we are here starts our webinar. This webinar has been organized by East African Law Society, and it is a construction law webinar. The East African Law Society Construction Law Committee is conducting this webinar to discuss the emerging trends, common risks, and the challenging arising various stages of construction projects in the East Africa region. So during this session, the speakers will address the following topics: an overview of the construction markets in East Africa, the future of construction law in the East Africa market, opportunity for the new entrants in the market, lessons for new players in the market, challenge unique to the region. And after completing this discussion, we'll have a session of Q&A, question and answers for both of us. We have two speakers. We have two senior advocates who will be organizing this session. One is Mr. Kagwa, who will start to discuss with the recent development in the construction markets in the region and perhaps global. And second will be Mr. Sonia, who will then discuss the opportunities available to challenge and how lawyers in this area of practice can explore the same. Now I welcome the first speaker, Mr. Kagwa, to proceed with the webinar.
Good afternoon, dear participants.
Hello, Mr. Deputy Kagwa. I welcome you.
Okay, thank you. Good afternoon. So I'm going to start off my presentation. It is straight to the point. The topic is the East African construction market, exploring opportunities and challenges. All I need to tell you, members, is that the business of construction is not just in East Africa. The opportunities are Africa-wide. So in East Africa, of course, there are opportunities, some of which we know, like in Tanzania, there's going to be the standard gauge railway, and in Uganda, there's also going to be a standard gauge railway. But we should not restrict our practices to only what is happening in East Africa, because we have capacity to do business in the rest of East Africa, even the rest of the world, for as long as you have the competence. So I'll go straight to the projects that we need to look at, and my colleague, my senior colleague, Mr. Swanya, will look at the opportunities. I'm just going to look at the projects, we'll do the opportunities. So, not far away in Egypt, there is a new administrative capital which is coming up, the Smart City in Egypt. Project began in 2015. It plans to accommodate 6.5 million people. The total cost is $58 billion. So you can imagine the amount of business that is just in Egypt now, even before the project is complete. There is the Dangote Petroleum Refinery in Nigeria. It's capable of processing 650,000 barrels a day of oil. It sits on 2,635 hectares of land. It's going to cost more than $12 billion. So this is a sign that there's a lot of capital coming into Africa. So we don't need to restrict ourselves to only what is happening in East Africa. There's the Grand Ethiopian Renaissance Dam in Ethiopia. Its total cost is $5 billion. It is planned to produce 5.15 gigawatts of electricity. Right next door, the Kenya government allocated 2,000 hectares of land for the project, which is the Konza Technologies in Kenya. It's $14.5 billion. It is planned to generate over 20,000 jobs. There's the Grand Inga Dam in Congo. It's planned to generate 70 gigawatts electricity. Total cost is $100 billion for a total of 7 or 8 dams. So Congo, as you may know, there was an application that they joined the East African community. So it is something to look out for. It's virgin land for all of us. The 6th of October city in Egypt, total length of the rail is 42 kilometers. It's going to connect 12 stations. The new administrative capital in Egypt, it's 54 kilometers length. It's going to connect 21 stations. Now, in Nigeria, the seaport that is coming up is capable of handling vessels weighing up to 45,000. The Lekki Deep Seaport has 3 terminals, a 1,200 meters long quay, 3 container berths, and a storage yard with 15,000 ground slots. So you realize that there's going to be a demand for lawyers who have specialized in maritime law, as a lot of business is happening at the sea. There's a Greater Tortue Ahmeyim project in Senegal. Its production capacity will be 10 million tons of liquid nitrogen gas per year. So those in oil and gas, there's business in Senegal. The Suez Canal in Egypt have so far displayed already 3 projects in Egypt. So the plan is to expanding the southmost part of the canal from 30 kilometers to 70 kilometers, to be dredged to increase the depth of the canal from 66 feet to 72 feet. As you're aware, FIDIC has already come up with a book on dredging. So those who practice construction law and know FIDIC, there's a lot of business in Egypt for this canal. There is the Kakulo Cabana Dam in Angola. Its expected capacity is 2,175 megawatts. It's 103 meters high, 553 meters wide. It will cost $4.5 billion. The Ghana National Railway Project, $21.5 billion. The Redstone Solar Thermal Power Plant, South Africa, planned to generate 100 megawatts, which will cost $715 million. The Grand Theater of Rabat in Morocco, 55,000 square meters, performing arts in Rabat, it will cost $143 million. The Kumasi Airport in Ghana, $75.23 million. It's an expansion. The F Tower in Ivory Coast, 283 meters tall size skyscraper, 64 stories that will serve as office space, and the 200-seat auditorium. The Grand Egyptian Museum, 50,000 square meters of land, to cost $550 million. The Kribi Deep Sea in Cameroon, first phase of the project was completed in 2015. It's capable of carrying up to 1.5 million tons. So you realize that many of us had ignored maritime law. It is time to go right there and see what's happening in Cameroon, Nigeria, Senegal. Then there's this Tanzanian standard gauge railway. Total cost of first 2 phases is $2.35 billion. Then in Nigeria, there is a $3.3 billion port that is coming up with a capacity of 25 million tons per year. The port will also handle up to 6.5 million containers per year in its 23 terminals. So, having highlighted the projects that are happening all over Africa, the question we need to ask ourselves is, so what? And how do you go into that? My colleague, Mr. Swanya, will go into the detail of the opportunities. The only thing that I need to tell you for now is that the best way of strategizing yourself to be able to get onto these projects in Africa is you need to have competence. So the number of institutions in Africa that give you an opportunity, once you have the necessary training, to join there either as an arbitrator or a mediator or as an expert or a mediator to wait and see whether the business is going to come in there, because most of all these construction projects have arbitration clauses. So from what I have shown you, it shows you that there's a lot of capital coming from all over the world to Africa. So there's a focus on infrastructure development in Africa. So where capital flows, obviously disputes follow. And if disputes follow, then the next thing is, what is the forum for resolution of those disputes? All standard construction contracts that I have read have arbitration clauses. So I invite you members to join arbitral institutions for training and to be empaneled in order to share into the business of contracts. So I'll start back home, Charity Big, a think tank which was established to bring together players in the construction industry. And it does training in construction law. We do training in FIDIC and other standard contracts. There is ICAMEC in Uganda, the International Center for Arbitration and Mediation in Kampala. It's an arbitral institution which administers arbitrations. And many of the international clients have adopted ICAMEC clauses, which means that there's business here under ICAMEC. Then they see the Chartered Institute of Arbitrators. It is the gold standard for dispute resolution. So anywhere you go in the world, for you to have CIAB, you are recognized as competent enough to handle dispute resolution. So for some of you who have not joined CIAB, I encourage you to do so. In Nairobi, there's the Nairobi Center for International Arbitration. They administer arbitrations. There's a lot of disputes in construction there. There's the Africa Arbitration Association, which brings together arbitrators in Africa. They are planning to have a conference in Cape Town in October. There is the Cairo Regional Center for International Commercial Arbitration. I have showed you there are 3 mega projects in Egypt. So some of you who are experts or who are arbitrators, you need to get empaneled in Cairo because there's business. There is MIAC, which is the Mauritius International Arbitration Center. You realize that most people who invest in Africa have their companies incorporated in Mauritius because of their ease of doing business. And also because it's a tax haven. So getting registered there gives you opportunities to tap into the business that is coming in from infrastructure. Then in Asia, as you realize that some of the financials are from Asia, there's the Hong Kong International Arbitration Center. And in the UK, there's the LCIA. So you realize that whereas it's in London, almost 50% of the disputes that get handled there originate from Africa. So getting registered there gives you credibility and you're likely to earn much more. The ICC, the International Court of Arbitration, it opened shop next door in Kenya. It was launched last year. So these international centers are seeing that there's business in Africa. There's KIAC, the Kigali International Arbitration Center. They celebrated 10 years last year. Rwanda has registered itself as a place which is good for doing business. So getting registered there is also good. There's the Asian International Arbitration Center. There is the Singapore International Arbitration Center and the Dubai International Arbitration Center. So that is my presentation. And over to you, Senior Counsel, Mr. Swanya, to take us through the opportunities and the challenges. Thank you for listening to me.
Oh, thank you very much, Mr. David Kagwa, for your education. Mr. David Kagwa is an international arbitrator and construction lawyer with over 18 years of experience in representing clients in resolving complex disputes involving and construction projects. Thanks very much, Mr. David Kagwa. Now let us go to the second session, which will be conducted by Mr. Victor S. Ogeto, who is a senior advocate and managing partner of Sanya and Company Advocates. He has a MBA, he has LLB, he has diploma in KSL. He is a commercial mediator in UK. He is also a member also of International Arbitrator, and quite his experience in construction law and infrastructure projects. You are welcome, Mr. Victor Sogeto, for the session.
Yeah, thank you so much, Elder. Thank you. I still have trouble connecting through my laptop, so I'll be using my phone to present. And I'm hoping that Gabriel got my slides. If we can display them, then from there we can start. Perhaps I see it does this, the display. I want to thank also my colleague, David Kawa, for a wonderful presentation. It's really magnificent. When you look at it and the projects taking place in Africa, you think really we are on the right track. So my line is about opportunities, challenges, and approaches by lawyers how to get in this business. But I want just to give a remark, and the remark is my personal experience that whether we are in the practice of law or medicine or anything else, all is business. And in business, you always be required to have a dream, and your dream, a big dream, should be a dream that goes beyond possibilities. A good dream requires that one should be also organized. You should be able to engage, and you should also be able to deliver and deliver smart. Once you have those attributes, it's very easy for actually opportunities to follow you. You'll be able also to deal with the challenges that may come on your way. And you also be able to realize, tangible results out of the opportunities. Opportunities are everywhere. I mean, looking at the presentation my colleague has put, you'll see those are really huge, huge opportunities. But before I get into that, I thought maybe we needed, my first slide gave points that I want to discuss on. First point was construction law principles. Then the second was conveyancing. The third point, we look a bit on construction project management. Then we'll also look a bit on procurement reforms and legal framework. My colleague has touched a bit on alternative dispute resolutions. We'll touch some little details, not so much into it. Then we look at the East Africa Community Treaty protocols and touch briefly on litigations. Why I thought we needed to look at the construction law is because the doctrine that manages contracts is one of the greatest opportunities, I think, that we have in construction itself and construction law disputes. And the two main doctrines, one is freedom of contracts, and the second one is also principle of pacta sunt servanda, which mainly means agreements must be kept. Now, the first freedom, the first doctrine, freedom of contracts, it allows the parties to have freedom in what they have agreed to do to each other. That's once they have signed the contract should run the way they want it, unless it offends public policies. This was confirmed on a case of APIC Group contractors versus Transfield BT Limited, where the contract had an arbitration clause, and one party had wanted to assume that that did not matter. But in the judgment, the court ruled that the intentions of the contractors has their own freedom and it must be honored. Now, the same applies to this second principle. The agreements must be kept. It governs the performance of contracts and is a fundamental principle in contracting. You can imagine in a regime where you are not sure whether what you have agreed with your whether my laptop, and I will be able to show also the slides. Sorry for that small itch, but I think we're getting there now. So I was saying, you can imagine, you know, an environment where agreement must be kept. It's a great opportunity for contracting industry. I hope everybody's getting me.
Yes, but your voice is not audible. Could you please keep your phone nearby? As you have said, your computer has got problems. Keep your phone nearby so that you can be audible.
All right. Let me just.
Yes, now we get it.
Now you get me? So I'll
yes.
continue. Yeah.
Yes, now we get it. Yeah.
Now, also, I think it's important also to look at some body of construction principles. I'm saying this because when we'll be looking at what my colleague said, areas of arbitration, areas even of litigations, you need to have the competences to deal with that. So among the really prerequisite, you need to understand some of these principles that govern construction industry. So some other principles is, well, in French, robusta 6 standardized means things must stand the way they are. I mean, where there is been a fundamental change of circumstances.
Recording in progress.
Hello.
Hello, Victor. Maybe you should mute with maybe the phone. You stop the phone, then use the computer. Or if you use the computer, please stop the phone, then you proceed with that.
Is it clear now?
Yeah.
Is the voice clear? Okay. So I was talking about.
Maybe you can adjust your computer so that we can see you. Yes, there you are.
Okay, great. Thank you. Small itches here, but we will proceed. So there are these other body of principles that must be also, we need to know. The principle
signing contract in good faith, the stability of direct variations do not constitute any breach of the contract, and also where conditions differ from the tender, the employer will reasonably increase the contract price. Another principle is risk on unforeseeable fiscal conditions. There's another principle that also touches on construction methods. Construction methods and processes. We have also another principle on damages and the compensation. Now, so having touched on those principles that are very important in construction, and why I decided to pick on them is because when it comes to opportunities, when it comes to challenges, when it comes how lawyers are going to explore and exploit the opportunities, suddenly you need to have the competence, you need to have the competences, you need to have the knowledge, you need to know the construction law itself. And if I may just bore a bit, if you got the projects which are going on in Africa per se, these are huge projects, complex projects. And if you do not, if a practitioner does not have the knowledge of even the construction itself, their implications, their technicalities, now it becomes a little bit a challenge for you also even to draft contracts or even to guide your client. And therefore it's important to take time and have knowledge on those principles. So now we'll turn to the next slide, which now I will talk more about the opportunities, and that is conveyancing. The next slide on conveyancing. So on conveyancing, and my colleague did mention about these huge projects that each country is actually doing. In Kenya itself, we are already working on budgets to build an average of 500 house units per year. Now that is under the public sector. If you look at the amount of construction that is going through government, providing affordable housing, which eventually will be offered to the citizens to buy, you can imagine the amount of conveyancing work that exists in that. And this is repeated not at the national level itself, but also it's going down to the counties. Now, I believe equally many governments in the East African community are endeavoring to provide housing. I did read some document, I think in Kampala, where the national scheme has started building out of affordable houses for its own people. So the construction of housing, whether it's the national level, the county level, or pensioners, provides huge opportunities for lawyers, mainly on issues to do with transfers of what has been purchased into ownership, doing charging for the ones who want to seek loans. So there's a lot of work available for lawyers there. What are the challenges? The main challenge which I see in conveyancing is purely the one I think is the capacity, or I would call it an organized way of getting some of this work to the practitioners. You will find, because of the cost, the most practitioners are asking to do conveyancing. You find most of the clients prefer using other methods, unconventional methods, you know, or maybe in-house advices. So one, cost is one of the challenges, and yet that can be overcome, especially once you consider the large-scale work to lower the costs. I think in Kenya here, what we've tried to do on conveyancing, especially matters to do with land, property, we have tried to cap so that we don't go beyond. We don't use the value of the project or the value of the land or the house, but cap it to an affordable fee, which I think is working very well for most of the users. We'll also see that still under conveyancing, we have now the private sector. And what I can see a lot, for example, in Kenya here, because we have just had a land reform where a person can buy an apartment and have a title deed. So what does that mean? That means a 1 acre land, you can do apartments and you can have several owners, as opposed to previously where a title deed was only available to the owner of the land. But with this reform, what it means is you can have several apartments going up, and then many owners can buy, and they have the rights to that unit. They can sell it, they can use it for security, which is a great opportunity. That reform has brought one. That reform has allowed many investors to come in now to do apartments, to provide housing. And we've experienced quite a large construction, is particularly on apartments and mainly in the cities, in the counties. And that has, of course, created a great opportunities for the legal fraternity. There's also private partnership in projects. And this mainly is covered under what one could say public projects. But then what happens is you find private firms contract with the government to do a project, and slowly we're looking at some of these projects out there. And then with an agreement, perhaps they will, for example, if you take the recently built Nairobi Expressway, where the private contractor financed the entire project, but he will run it and recoup its investments, and then, of course, hand it over to the government. Now, those are some of the kind of public-private partnership which are practiced. Now, because of the land reform, right, and these reforms that have been introduced by government, so it creates opportunity to have investors to come from out, right, to put up these projects, first, of course, for their benefit, for their profits, but in the process, they equally create opportunities for various practitioners, and also included there is the employment aspect. Now, I thought also we look briefly on how some of these projects are delivered. That's my next slide. The construction project and management. So there are many ways of delivery of this project, but I've just picked about 4. The first one is the design, build and build, bid and build. The second one is design, build, which including engineering, procurement, and construction. Then we have engineering, procurement, construction management, and build, operate, and transfer. Now, why is this concept of delivery of project important? In most constructions, time is of essence. How long the projects take is very important for an investor or for the party that has contracted, including even the contractor itself. The question of finances is also very important. So I think the construction law as adopted and adopted more or less as a conventional way of delivering these projects in a way that the parties have agreed. So for example, you find the design, bid and build, what that involves where employer designs, does the drawings, specifications, and the bids of quantities. And then he puts the project out there for the contractors to quote, right? Now, this project, when undertaken, of course, the contractor who does the project, yeah, has a responsibility to run that project within the budgets and within the expectations of the client. And normally the engineer, there's an engineer hired to administer that project, and the payment is based on the work done. Now, the whole concept of this method of delivery, it gives responsibility both the contractor and the client, right? So the contractor has a timeline within which, because if he goes beyond, then of course he loses out in terms of cost, because already the project, they have agreed which method, which way they're going to deliver that project. And that applies to this other project. For example, the second project where it's design, build, engineering, procurement, the contractors design, the employer's requirements, the employer specifies the purposes, the standard scope, the performance criteria of the work. It's a lump sum price contract. Payments are done according to schedule, and the type of contract delivery gives the employer high rate of prediction and timely completion. The other one is the employer contracts directly with the subcontractors on a lump sum basis. Construction manager is hired by the employer on a professional service agreement basis to coordinate them. And of course, the construction manager is liable for the entire workmanship, but not for the work of the subcontractors. Build, operate, and transfer is a common method of delivery where normally you find that the contractor does a job, he runs the project, and after he recoups his profits, then of course he hands over the project to the government or the parties that hired them. The next point, which I think again is a good opportunity here, is the procurement reforms. Previously, before the procurement reforms, I guess in most countries, it was a bit difficult how to control procurement. There was no proper standardized way of doing it, but now with the reforms, it has brought in a standard way of monitoring and assessing procurement processes. That's a good opportunity because it brings up fairness, it brings up transparency, it brings up accountability. So with that, then you find the investors are interested. Why? Because the procurement is more transparent than previously. You are able to compete transparently and compete against each other without much bias. So you have the Public Procurement Regulatory Board, which does that. You have, of course, the regulations and procedures. You have the issue of transparency and quality control. You have the issue of Public Procurement Administrative Review Board. Now, just in case things have not worked properly, then you still have a review board within that regime to deal with anything that has aggrieved a bidder. You have also the procurement dispute resolutions, and of course the procedural tendering accountability. Now, this reform, it creates in an environment that the bidders, the contractors, always will feel if they entered into the work, there will be accountability at the end of the day. There won't be any bias. The issue of corporate governance is more or less taken care of under the procurement reforms and the legal framework. And therefore, it allows more investors to participate in a given region. And what does that mean? That means as more contractors come in, as more work is being done, then of course, the work is created. Work is created in literally across board. You have employment is created. You have these products are created. There is the contribution to the overall economy is contributed there. And more importantly for the lawyers, then is work is also created for the lawyers. Why? Because in every processes, especially on projects, very few projects will run without having challenges. And of course, when those challenges come up, the next stop is legal, is practitioners. So you find, for example, in Kenya here, I may say, we have, of course, lawyers who have specialized on procurement law. That's their specialty. They're able to come in to attend to clients who have been aggrieved because maybe they feel the process was not properly conducted, and so they come in to see that their grievances are met. That takes me to my next slide, which now also looks at what comes out of these projects. As I said, very few projects run without challenges. And the disputes arise, claims arise. You have sometimes substandard work is done. So these grievances, one would see it from a legal perspective, is a great opportunity for the lawyers. Because then the lawyers have to come in and see how they can attend to the grievances of their clients. Now, we have, I think about now, very conventional, about 3 ways of dealing with some of these challenges. My colleague did mention more of arbitration. I will talk a bit on other dispute resolution, that is negotiations, mediation, and of course, I will talk also on arbitration. I think he brought out very clearly that in East Africa and maybe in Africa and many other places, we have several now arbitration centers that are listening to grievances brought by, various players in the construction industry. So let's now start with negotiations. Negotiation is defined as a communication between 2 parties or more willing to talk with each other. It focuses on developing mutual acceptable understanding or agreements to address issues of concern. Negotiating disputants may directly represent themselves or an agent, family member, technical expert, or an advocate for that matter. Negotiations are normally the primary approach to solving a dispute, and lawyers who have done mediation, they will find that mediation is friendly. It allows parties air all their views, bring out the perspective of the issue itself, which they can't do in court. Courts are normally rigid, but in a negotiation, then your negotiation, of course, you parties get themselves time to bring out their issues so that they can understand each other. Moving to mediation equally, the practice is a practice that is out of court process with a neutral third-party mediator. Outcome does not preclude court process. In other words, once you have not agreed, you can still proceed to court. Both parties' consensus may be adopted as a record of court for enforcement. Its process is not adversarial, neither does it require, an advocate. And of course, the approaches that the whoever who's involved in it needs to approach it looking at the conflict analysis, where you understand the causes of the conflict, opportunities for collaboration as you resolve that. Now, then we move to arbitration. We move to arbitration, which my colleague did mention. The experience I've seen, more contracts, especially construction contracts, lately they have an arbitration clause. But the definition of it, according to our act, the Kenyan Act of 1995, defines it to mean the processes precludes court process other than buyers in part of their arbiter or the process itself. But the outcome is binding for both parties. Arbitration is more or less a private prosecution where parties choose their procedure, they choose how to do it, guided under the New York 1958 Convention principles. The key things there is to pick the seat of arbitration, and of course the parties choose the arbiter. They will pick the applicable law. They will also and language. And of course, there comes the recognition and enforcement of the award itself. The rules of procedure must be agreed. Now, some of the challenges which are in arbitration, one is as opposed to where we thought that arbitration is faster. Yes, it is faster. And I'm saying this because I've done a paper where I compared mediation with arbitration. But you find there is much interferences from court, where a party is aggrieved, he will run to court, and the court has to listen to him. And that tends to slow down the arbitration process. And yet is a cost-effective, fast, right? But it does start equal challenge where an aggrieved party would always run to court to seek reliefs on the areas where they think there is bias or there is the issues of jurisdiction and all that. The other challenge I see in arbitration is enforcement. Once, of course, the award is given, it's supposed to be adopted, you have to go to court. have it adopted, and of course enforce it as an order of court. Now, so talking about the region itself, the East African region, depends where you've done your business. Still, you have the issue of domestic laws, the conflict of laws, where perhaps a number of other elements may come in to delay the process of enforcement. I think it's a legislative issue which needs to be looked into, so that once a word is given, irrespective from which country, then the enforcement should be equally much efficient, but more, it is actually the law that it must be adopted by the country where you trying to enforce it. That takes me to opportunities within the community, and I want also to concur with my colleague. There are so many projects which are being carried in the community, actually Africa as a whole, but even more important in the East African community. If you look at the Program for Development in Africa, BIDA, it has the energy, it has transport, it has boundary water project, ICT, and these are huge projects. Of course, they create great opportunities, right? And at the same time, equally, they have the challenges. Some of the challenges which I think the community is trying to address. One, there is the issue of funding, of these projects, which will now, of course, affect the sustainability of the same. There is the question of technology itself. We do not have fairly qualified technical people to handle some of the projects. And as a reason, therefore, you have to rely from our international community to supply labor, which is highly technical. Of course, most of these projects, they require sophisticated machineries, which a lot of it, we do not have. They have to be either hired or supplied by the international markets. But having said that, it creates huge opportunities in the sense that employment is created, the actual products are created within the respective countries where they are done. They increase the GDP of the respective countries, and of course they eventually improve the livelihood of the people. How do lawyers explore in those areas? Currently, I think the lawyers rely on their local contacts to get work in those projects. But more than often, most of these projects are done by multinationals. Then they're likely to tap in the international legal fraternity. But also there, it's possible that such agreements, they would look for the local practitioners who they can join together so that they can provide services in the given project. The other point, looking at it from the East Africa Law Society, is something that I think should be explored, how the society can pitch up or put up a legislative to the community itself, so that the practitioners within the respective areas of operation get either get some preferences. Maybe preference is the wrong word to use, but they become the first stop, so that before the international community is hired, right, then we probably would get a chance given to the local practitioners, because I believe we have quite enough expertise in the respective areas who can offer reasonably good job. And in any case, most of this work, besides the fact that a multinational law firm is spearheading a legal issue, but they use the locals to do the job. So a legislative to the community to have the members of the East African Law Society as a first stop. And if they cannot meet the requirements, then of course the party is allowed to shop out, would be of interest. Finally, still we cannot do away with the litigation, especially when it comes to the community. All these projects we have talked about, you'll find some of them which don't have the arbitration clauses. Then of course, they must go through the normal way of court process. Now, the legal fraternity within the East African community, I guess, though I think the protocols are trying to how to harmonize the services, or to allow the legal practitioners practicing in any of the countries, but still we have barriers. We have language barriers, and I don't think that has fully been adopted. So that the opportunity that is there is now where partners, we have to look agencies. We find maybe Kenya, you get an agent in Rwanda, get another agent in Tanzania. So if there are issues, we can share, and of course you have a representation on that side. And if there are issues on Kenyan side, you have an agent, your partner you work with, then of course they'll be able to handle the litigation issues. Why I'm saying this is because currently the trade is ongoing. There's issues of labor. There are issues of defaults here and there, and the majority of those trading don't have clauses like arbitration clauses, which is more flexible, and it goes beyond the borders. So you find if an action has taken place in Kenya, then you have to find a law firm in Kenya to handle that particular issue. So litigation is there, it has opportunities, they have those challenges, but our legal practitioners can overcome that by finding out suitable partners in the respective countries so that they can deal with that. Then, of course, the other aspect to look into that is when it comes to issues of judgment and executions, public policy doctrine, then a respective law firm will be able to give direction or much efficient services in their respective country because they know. So that is really all that I can present on issues of opportunities, challenges, and how the legal fraternity could deal with that. Thank you.
Thank you very much, Mr. Victor Swanya Ogeto, for your presentation, for a well-elaborated presentation. Thank you very much. Now it's the session for question and answers for all of us. Understood somewhere, or have a question, please, you are welcome. Anybody with a question? Who want to ask anything concerning the presentation?
Hi, Miss Queen. I think Enrica Dulo has her hand up. She's ready to speak.
Yeah, of course. Can you allow him to speak? Hello? Hello, June. Can you
Yes.
allow her to speak?
Yes, our host Elmad is on the call. You can unmute Enrica to speak.
I don't see her here. I don't see her. I don't see her in my speaker.
Hi, you've asked me to speak. This is Enrica
Yes.
from Kenya. Thank you. It's been a wonderful presentation. I don't do much of convincing, but I mean, looking at the projects going around in Kenya and in East Africa, it's important that we equip ourselves, and it's important to know even how to integrate regionally. Am I audible?
Yes, now you're audible.
Sorry, I was commenting that considering that there are a lot of projects going on, whether they are intergovernment or by private developers, it's important that as advocates within the region, we equip ourselves with the knowledge, because the legal processes that are involved, the work will come to us. And remember, no one teaches you construction law in law school, but these are some of the areas of practice that we come across now when you're in private practice. So the webinar has been on a point. It's good, and even in Kenya, as a secretary to the Lady Law Firm Practitioner Society, I think this is also one of the practice areas we need to take seriously and engage our members in. So thank you very much, East African Law Society, for organizing this. It's timely, and probably another session will do us justice. Thank you.
Thank you very much, Enrica, for your comment. Thank you. Anyone, please? Any comment, Mr. David from Enrica? Comment?
Yes, Queen.
Yes, Mr. Kago.
Yes, thank you. I just want to make a response to Enrica from Kenya.
Yes.
Whereas it is true that in law school, there wasn't a specific topic on construction law, you realize that a big number of universities that teach construction law are in the UK, Australia, and Scotland. But however, we've set up the Construction Law Institute, which is bringing together professionals that have worked in the construction industry and who are qualified. And we are doing specialized trainings in construction law. So you don't need to necessarily learn it from practice. There is an avenue where you can do the trainings. So you can reach out to me just in case you need any specialized trainings. But the main purpose is to make sure that this knowledge is passed on to all those that need it, to ensure that we have very good practice in Africa. Thank you.
Thank you very much for your comments, Mr. David. Mr. Victor, do you have any comments concerning Enrica's comments?
Hello?
Do you have any comments from Enrica's?
Not quite. That's not quite. I think I'm grateful that in Kenya we have that institution which offers specialized training on construction law. And it's true that I think previously, before this, most practitioners, they learn through, baptism of fire. You get to draw contracts, you get to be there to deal with them. But I'm sure that with now the institutions around, that's great. Also, there's also something else that we need to share, that we have a lot of books available on construction law. We have a lot of books available for construction law, arbitration law, and they have, I think, good precedents which also can gain the practitioners. So once I think you get yourself equipped with also those kind of materials, the practice is more or less the same in terms of the experiences that people go through. So and again, the other aspect is again, I think most countries, like in Kenya, we have now acts. We have the Construction Act, which looks into the issues of standardization, issues of quality of materials, and issues of procedure, and including also qualifications of the contractors, including the qualifications of contractors who can handle what kind of projects. So there's a lot happening in the construction industry. There's a lot happening in the construction industry, but I will invite as many lawyers, of course, to launch into this discipline of construction, and including also the maritime. Very, very interesting areas. Thank you.
Thank you very much for your comments. So, any question? Any questions?
There's some questions on the Q&A.
Okay.
About 5 questions.
Oh, okay. Okay, I've seen some of the members, they ask a copy of a presentation. Okay, this will be shared after talking to the speakers. Then you will meet them on the emails. And please, let me see the other question. Can they share copy? Okay, members ask if we will share the presentation. We will talk with the speaker, and then the presentation will be shared to the trailing mails. I think this is clear.
There's some questions in the Q&A section. Like Susan Joroge is asking, kindly give more information on the Construction Law Institute. There's another question.
Yeah, okay, I've seen them.
Yeah. You can read them out so that the panelists can respond.
Oh, okay, fine. Hello, Mr. Victor David. There are some questions in question and answers. Somewhere is written here. I can read for them. But one, what is the impact of a criminal conduct by a party in contract with the reference of arbitration clause, giving a check without fund to pay the debt? Will the other party can follow in criminal proceeding for the payment and denounce the agreement for the criminal conduct?
Now, that's a very interesting question. An arbitrator will basically handle literally everything else. Now, issues of criminality is part of what an arbitrator can handle, possibly to determine, yes, there was a crime committed or a fraud, and then refer the matter to the relevant institutions. So I believe like it is in Kenya, if the matter is determined there was a fraud, then certainly it will be referred to the right institutions to deal with it, because fraud is criminal. It takes a different approach completely. But then the role of an arbitrator is actually to determine what is being alleged. That's what they determine. Because if a check was issued, that has to be determined that a false check was issued, that was or a check was issued in pretense. All those are matters to be determined. Once they're determined, then they're referred to the right institution to deal. I hope I've answered whoever who came up with.
Yeah, of course. It was anonymous attendee. I hope he has heard your answer. Also, there is this question. Someone is asking, has reached out other lawyers in the region to ensure that local lawyers are hired in the major infrastructure projects?
Come again? Read again
They're
the question.
asking that, yes, they're asking that if we have made follow-up to make sure that some local lawyers are being hired in the major infrastructure projects.
Yeah, you know, that's what I said, that I think the East African Law Society, together with their partner societies domiciled in their respective countries, they need to pitch a legislative issue before either EAL or the respective national assemblies, so that the law societies comes the first step before the multinationals come in with their legal experts or legal institution firms. That way, then, of course, it will give an opportunity to the local lawyers, you know, to have a chance to compete. Now, remember also that we are in a democratic society. We are in a free market. So laws cannot come to make individuals decide what they don't want. So given that, I think what is left is that the law firms really not need to be smart. They need to be competent. They need to, you know, to present themselves as required and compete with others, and also do networking, probably with the other international law firms. So create some kind of agency how they can work together. That's really what I can say. It will be difficult for any institution to ensure that the law firms, the local law firms, get work. That will be a tall order, given the market environment, which already, which is very important for the purpose of investments, and the doctrine I just earlier said that the most important fundamental doctrine is for the party's freedom to contract.
Thank you very much, Mr. Victor. Someone also is Esther Mlingwa. He wants you to address the relevance of banking and the insurance law in construction law. He thinks that she thinks that these are also important areas of consideration in construction law.
Perhaps we could also hear from our other panelist, Mr. David Kagwa, also.
Okay, so which question can I address?
Okay, there is this relevance of banking and the insurance law in construction law.
It's extremely relevant.
Yeah.
To begin with, at the time of signing the contract, if it's a construction contract, before money is paid, the advance payment, the employer requires the contractor to produce an advance payment guarantee from a bank. So that is one. Secondly, upon signing, there's a timeline within which the contractor should produce a performance guarantee. So these two guarantees are extremely important at the commencement of the relationship between an employer and a contractor. So obviously, the law that governs issuance of performance and advance payment guarantees is the law of banking, because banks are regulated by various central banks. But in certain low value contracts, the employers accept insurance bonds. So if an insurance bond is issued, then obviously insurance law applies. If performance guarantees or advance payment guarantees are issued by a bank, then the law of banking applies. So those are the two areas where it's quite relevant. And obviously when there are disputes, for example, if the employer alleges that there was a breach on the part of the contractor and they go ahead to cash the guarantees, some of the remedies that the contractor may have to go to court and apply for an injunction to stop the encashment of the guarantee. So at that level, the court needs to apply the law of banking to decide whether to issue the injunction or not. Over to you, Queen. Thank you.
Okay, thank you. Esther Mlingwa, I hope you have understood your questions. Now, I think there is no question anymore.
There is a comment on the Q&A.
Ah,
section.
okay, yes, I can see,
Perhaps-
okay.
Yeah, we can let our panelists respond to the comments.
Ah, okay, okay. Okay, dear panelists, Mr. Victor and Dave, there are two comments here in the Q&A session. The first comment is the proposal to have some legislative framework to East Africa Authority to protect the local professional is key in the light of US government policy pushing African governments to open up practice.
I've lost you.
I think we've lost Miss Queen.
Yeah, we lost Queen.
Yeah, let me just read it out for you. The proposal to have
Maybe.
some, oh, she's back.
Yeah. Oh.
Sorry, Miss Queen, we lost you for a
Oh,
minute
okay,
there.
okay. The second, I will repeat the second comment from hello?
Yes, yes, proceed.
Do you hear me? Do you hear me?
Yes, yes, Queen, I'm hearing you.
Yeah, okay. Yeah, okay, fine. The second comment is there are also multilateral development bank, such
Yeah.
as the AFD, World Bank, ASEAN Development Bank, EU, that could be benefit from having local expertise in most of these projects. So these are comments from our attendees that they first that they want the proposal to have some legislative framework at East African Law Authority to protect the local professional. And the second comment from our attendee is that this multilateral development bank they think could be benefit from having local experts in most of the projects. Your comment, please, Mr. Victor.
Well, the first one on the proposal to have some legislative framework at EALA to protect local professionals in key in the light of the US government policy pushing African governments to open up practices for the US professionals without safeguards. Now, I think in a way, I don't know, perhaps what happens in various jurisdictions, but normally a lawyer, an advocate, cannot practice in a given jurisdiction if that advocate has not been licensed by the respective society, law society. Unless one gets exemptions, which normally would be given by the country's attorney or registrar of judiciary. It depends what the law provides. Now, what that means is still as much as the US pushes for us to open the professional space, I guess that policy remains, that act remains, that the respective law societies in the countries will have to issue a license, or one has to get a permit so as to practice. But I also do agree, just like it is, you cannot go to America and practice unless you're licensed. So that's a mechanism that gives protection for the local practitioners. Now, nothing stops a foreigner who has been licensed to practice, just as much as we have locals who have passed the bar exams in the US, in their respective maybe state, and they're able to practice. I think what I must say here is, as much as we may want to seek a legislation to protect the local practitioners, we must understand that the global market has become really a village. Competences, qualifications is what is going to give us an edge over our competitors. So as much as that is being asked, but let's do our best, because I think my experience is that the continent has some of best practitioners. Even out there, the most people practice, they are of the African origin. So that's what I think I can comment on that proposal. It's a good one, yes, but we can look at it maybe where, yes, the foreigners can come in, but let it be in partnership with the local practitioners. That's, am I there? Was I lost?
No, you're
I
not
was lost.
lost. We had you.
No,
You're okay.
I'd finished. Was I lost on the way? Did you get me?
I don't. Yeah, I hope everyone gets you. Everyone gets you. For the moment, we have so far we don't have any more questions. Cynthia, is there any questions from your side?
There's a comment on the comment section where someone is saying a session on contract drafting and management for such project will be helpful in light of the recent development in this area. I think Mr. David Kagwa had mentioned something on training. Perhaps you can, I don't know if Mr. David has a response to that comment or more information on the trainings that he conducts.
Yes, I do have a response. Now, the response I would have is that almost all these major projects that you've seen, which are in billions of dollars, are funded by the World Bank and other multinational development organizations. Now, the World Bank signed a contract with FIDIC, which is the Federation of International Consulting Engineers, to use their standard books for their projects worldwide. So wherever you see a project worth more than $10 million in Africa, it's most likely that the governing contract is the FIDIC, which means they are standard contracts, so you don't draft them. They were already drafted by the Federation of International Consulting Engineers. The only skill you need is, first of all, be able to interpret them and understand them. But also you need to have the skill to draft the conditions of particular application, which of course take precedence over the general conditions of contract. So we do have trainings under the Construction Law Institute for the FIDIC conditions of contract. But obviously, if East African Society can organize a training on the FIDIC contracts, I'll be available to assist our members to that extent. So one way of tapping into these construction projects as a lawyer or mediator or arbitrator or an expert is you need to understand the FIDIC conditions of contracts. Thank you.
Thank you very much, Mr. David. June, have you any other question from there? For me, I don't see any more.
I haven't seen any more questions, but thank you, David, for your response. I just wanted to respond to just a little something small that David has mentioned, perhaps to update our members who are on that. Yes, we will have a training, a FIDIC training on, of course, it's within this construction law committee. Information will be shared soon, and we really hope that our panelists will also be part of it. So
yeah.
If there are no questions, I just hand it over to you, Ms. Moderator.
Okay, even me, I'm interested on FIDIC part of contract. I'll be in among guys. Okay, I would like to thank all the attendees and the speakers for your time, for your presentation. We thank you very much, and I hope to see you in the next presentation. As you've heard, June has also commented on the FIDIC kind of contract so that all lawyers could be equipped with that. Maybe we can hear from you a vote of thanks from Victor and David Kagwa. Anyone can start for the vote of thanks. Yes, Mr. Yeah.
Well, thank you. Sampling once again to have the time to share some of these experiences. It's actually educative, and as you bring up relevant topics and enough time to prepare, some of these, like construction law, is very broad. Maybe we may want to look, for example, into some area and get down into the details. But again, that may mean a kind of a class. But I'm glad that I mean, we have a number of institutions that now members can get more knowledge so as to equip themselves. So we're grateful, East Africa and also Society, for giving us opportunity. Thank you, and God bless you.
Thank you very much, Mr. Victor. Hello, Deb. Can we hear your vote of thanks?
I wish to thank you, Queen, and the team at East Africa Law Society, and to my senior colleague, Victor Swanya. It was nice to meet you virtually. I hope to see you physically, maybe at the East African Law Society conference. I'll look you up just in case you're there in Bujumbura. And to all our members who have been able to register and attend, thank you very much, and hope to see you next time. Bye-bye.
Bye-bye. Thank you, Mr. David. I would like to take this opportunity to thank our East Africa Law Society, the Construction Law Committee, for preparing this presentation. Thank you, our attendees, for attending this insightful presentation. Thank you very much, and bye-bye.